I'm Nancy Springer, Committee Chair. Only board members who are members of the committee may sit at the table. Other board members who are in attendance must observe from the audience. If a quorum of the board is present, those members who are observant cannot participate in this discussion. Committee members Mike Layden and Paul Schifino have an excused absence for today. Laura, could you check for a quorum, please?
Nancy Springer?
Here.
Dave Diaz?
Here.
Joan Hancock?
Here.
Johnny Simpson?
Here.
So we have established a quorum. We will now do committee members and staff introductions. Identification by members of the public is voluntary. So starting with Christy.
Christy Shields, counsel for the board.
Amy Cox-O'Farrell, Chief Deputy.
Dave Diaz, board member.
Cindi Christenson, Registrar.
Nancy Springer, board member.
Laura Zuniga, Chief of Legislation.
Joan Hancock, board member.
Rick Lopes, Chief of Public Affairs.
Ed Lang, board member.
Richard Harbison, Pacific Advocacy Group. Nick Camerata, California Building Industry Association.
Lee Howard, North Coast Builders Exchange.
Joel Butt, Department of Consumer Affairs.
Mike Janetsky, CSLB staff.
Bree Brewer, Executive Analyst for CSLB. Cameron Foreman, Public Affairs.
Claire Goldstein, Public Affairs.
That's the PDRL licensing. Sorry, Legislative Division.
Thank you.
Thank you. I just wanted to make a comment in regards to being that the building official up there located in Butte County, and given our Oroville Dam incident, I just kind of wanted to send out some well wishes that things continue to go in good order up there, and that everybody remains to be safe, calm, and that they stay consistent with what they're being told by the Butte County Sheriff and DWR, and that all that ends up well. So well wishes to what's happening in our neighborhood north of us. All right, so do I have any other comments from the committee members? All right, hearing none. Public comment. This item, so this is agenda item B, public comment. This item is provided for public comment pertaining to items on the agenda as well as items not on the agenda. However, the committee cannot take any action on items not listed on the agenda. The CSLB welcomes public comment on any item on the agenda, and it is the Contractor State License Board's intent to ask for public comment prior to the committee taking action on any agenda item. But if for some reason we forget to ask for public comment on an agenda item, a member of the public desiring to comment on the item should raise their hand and they will be recognized. Also, we will be limiting public comment to 5 minutes per an individual. Hearing that, are there any individuals that wish to address the committee at this time? Okay, seeing none, we'll go on to agenda item C. Agenda item C, we have review, discussion, possible action in regards to regulations. However, due to concerns raised from legal counsel with some of the changes, staff will further review and bring this item back at a later date. So item C is going to be pulled from the agenda today.
You'll need a motion and a second to table for a future.
So moved. Second.
All in favor?
Wait, no, public comment.
Public comment? Okay, thank you, Christy, for reminding. So all of,
I think I need to.
roll call?
Nancy Springer?
Yes.
Dave Diaz?
Yes.
Joan Hancock?
Aye.
Johnny Simpson?
Aye.
Okay, so the motion is approved to move that off the agenda. Thank you. So agenda item D, let me shift to that, which is on page 31, 32. So this is the 2016-2018 strategic plan update, discussion and possible action on the 2017 legislative objectives. So if you look on pages 32 and 33, staff has proposed dropping some items 3.5 and 3.8. So Laura, do you want to?
Could I speak to that for a second? Or would you rather go through the whys first?
Sure, I'll do that and then discuss. So we're recommending dropping item 3.5. This had come from, I think, first come from enforcement staff. And as an alternative cost savings measure, we're sponsoring legislation this year to create a letter of admonishment that will hopefully reduce some of our enforcement costs. So we're going to concentrate on that for the moment and see if that's successful before pursuing alternatives. And then item 3.8.
Wait, 3.5, research alternative fee structures. Okay. Thank you.
Okay. And then also recommending dropping item 3.8. This was to track legislation amending Business and Professions Code Section 7031. We did track legislation last year that impacted that the governor signed. And then staff will, as always, continue to monitor to see if any future legislation is introduced and would bring it to the board.
So with Chair.
Go ahead, Joan.
Hi, thank you. With regard to that, I was going to ask to elevate that to an E, essential. I think that we have had over the last several years, we have had enough member participation with regard to 7031, generating some discussion, and I know some revisions have happened, but certainly not such that has changed it much. I'm also hearing that some, did you send a letter out with regard to this to board members in the last week or two?
No, not that I recall.
Okay. I just think this is really essential to contractors, and to see it be dropped from our legislative objectives, to me, is a huge mistake.
Okay, I'll clarify why I was recommending dropping it. It's not, I would say that I don't consider it to be significant. It is a critical issue to the board. It's just an essential function of what the legislative division does for CSLB, is to monitor any legislation. So for that reason, I was recommending dropping it, but it can certainly stay on, absolutely.
So other committee members, you got a comment in regards to this item?
I think the reason why I say that is there's some elements of it that, we could continue to work out, but to drop it from strategic plan, and that means not massaging it with other folks that are on the board, and I'd like to see that happen, whether by an advisory committee or in some other fashion.
I will add that I spoke to Paul Schiavino earlier this week, as he's unable to attend today, and it was regarding an unrelated issue, but it is still a concern for him as well, and so we did have some discussions. So we could, on maybe alternative solutions to look at. So we could keep it on the strategic plan and continue the discussion.
I'd be happy with that, and I would like to move that if a motion is necessary to do so.
No.
Not to leave it on the strategic
Okay.
plan, but I don't know if you want to take action with respect to 3.5, because that was your other recommendation. Ms. Zuniga had said potentially that you drop that one as well. So I don't know what the committee's desire is with respect to that. But if you want to drop 3.5, we'd need a motion on that one.
Well, let's, Dave, did you have a comment about 3.8?
No, that's actually that's actually what I was going to ask, if we needed a motion, so anyhow, we got the answer.
Okay, so let me summarize. It sounds like on 3.8, we want to keep that keep it in the strategic plan, so we are not going to drop that, so we do not need a motion with that one. So on 3.5, is everybody's committee okay with dropping 3.5? Oh, sorry.
If I could make a suggestion, Laura has a couple of other minor modifications she'd like to propose to the target dates, and if you could take all of those in one motion, that's okay with the committee. So.
Okay, thank you, Cindy. So what I think in doing that, we'll walk through the numbers first, and we'll take them one at a time. That might be an easier approach. Okay, so item 3.1, Lori, you have a targeted date of March 2017 on to present draft proposal to reorganize contract to state license law.
We do. I know this proposal has been on for quite some time, and I wasn't sure the committee would be comfortable postponing it any further. We do have a draft. Staff is still reviewing it, but I would suggest that if we change the target to May, we could put it on the May Legislative Committee agenda. I put language in the committee packet, and we could have a more substantive discussion at the May committee meeting, assuming we meet in May, and then could go forward from there.
So moved.
We're going to do them all at the end, so any comments about that? Everybody agree with that one? Okay, we'll move on to item 3.2, which is research increased penalties for predatory business practices, misrepresentation of services of need of services. We have that as important, and that is a target date of March 2017.
So we have started some preliminary discussions with enforcement staff. I think this would require a modification to the regulation as one alternative. It's section 884, I believe. So I think we've had some preliminary staff discussions, and I think we'll start a staff working group soon. So I would say, I guess we're on target for March 2017 and that we've begun work on it, but we won't have anything to present until potentially the next committee meeting. So we could either keep the target date or move it, depending on the committee's preference.
I'd like to move it.
May meeting. Public comment?
Thank you. I don't know, Laura, if you're planning on looking at the possible penalties for contractors that continually violate the electrician certification requirements. One of the topics that was discussed at a recent ad hoc meeting here on enforcement was the tendency of some contractors to simply pay what they believe is a very modest penalty for violating the certification requirements. But I think, at least on behalf of ABC of San Diego and WICA, they would support increasing the penalties for contractors who are repeat violators of the electrician certification requirements.
Okay, thank you. I'm actually not quite sure exactly what this will entail. I know the enforcement committee met last week. They talked, I think, on this issue and then talked about potentially charging the fee to enforce the electrical certification, but we'll make sure we include that in this discussion as well.
Question.
Go ahead, Joan.
Does this really give you enough time? I mean, even in May, researching in conjunction the appropriateness of penalties and statute. I mean, is that really giving you enough time, or us enough time, to research that with everything that's going on with this board, transitions and whatnot?
We could push it out further into the summer and save it for the next
What
following
do you
committee
think?
meeting. I would say that I've spent time on the issue, but I don't know that enforcement has spent a lot on what their recommendation is going to be, so perhaps it would be better to have more time so we could really identify the issue. I think one of the things that I've identified in the past reviewing this is that we're not always, even though the penalties are low in regulation, we're not even charging as much as we can, so it could potentially be difficult to propose increasing it when we're not already charging the maximum penalty allowed.
Go ahead, Johnny.
I think we should leave it in May, just in that if there's a problem or we haven't got it done, we can move it out later. I mean, it's.
We agree with that.
See if we can get it done.
Item 3.3, develop and implement regulatory proposal to formalize experience requirement criteria. That's essential, and that is targeted date of June 2017.
I think we're good with that one.
Okay. No change. Okay. Public comment? All right. 3.4, further define examination waiver criteria. That one is marked as important, and the targeted date is January 2018.
Yes, I think we're fine with that date as well. So the staff will do work on it throughout the year and can bring it to the committee at the beginning of next year. Although it may be potentially, I guess, February 2018 is more likely for the committee meeting date than January. So we could push it to February 2018.
Sounds good. Committee members, comment? February good? Public comment? 3.4? Okay. February 18th?
Did you say February?
February.
February 2018. Item 3.5, research alternative fees structures. That one is beneficial, and the target date is January 2018.
And this is the one we dropped.
Sorry, that one's dropped.
Why are we dropping this?
This is the one that enforcement had originally proposed as a way to achieve cost savings, and then we are sponsoring legislation on a different route to try to achieve those cost savings, so we're going to see how that impact of that.
We're going to talk about today.
That's on the agenda, that legislative proposal. Yeah.
So committee agreed to drop that item? Okay. All right, public comment? Okay. Item 3.6, review home improvement contract provisions. That is marked as important with a targeted date of June 2018.
And we don't have any changes proposed for this.
All right. Committee members, any comments? No changes, so public comment? All right. Item 3.7, increased fees marked as essential, and that one is July of 2018 target date.
We have this item on the agenda as well later on. That they'll actually be implemented July 1, 2017, so we're actually ahead of schedule. That's great.
Okay, committee members, any comments? Public comment? Okay, and the last item is 3.8, track and update board on any legislation seeking to modify Business and Professions Code Section 7031, and that one is marked as beneficial, and this was the one that was suggested to drop, but Joan is requesting to mark it essential and not drop.
I mean, if it's open to initiate new, I would ultimately like to keep it as ongoing, with the idea of initiating some sort of amendment, if possible, in the future. I understand the governor has signed this, et cetera, but if it needs to be massaged, or there's something we're forgetting, there's a strong enough concern that we leave it as ongoing.
Other committee members, we're going to keep that ongoing?
That's fine.
And do we want to change that from be beneficial to essential, or keep that beneficial for right now? Committee members?
Beneficial is fine. I mean, essential is something that you have to do immediately.
I'm good.
I know it's...
I appreciate the committee's willingness to keep it as ongoing, so.
So you're fine with beneficial?
Yeah.
Okay,
Thanks.
thanks.
All right.
So do we need a motion? Oh,
Go ahead, Johnny.
I'd like to make a motion to take 3.1 to target date of May, 3.2 target date of May 2017 as well, 3.4 target date to February 2018, 3.5 to drop, and I think I got it all.
And 3.8 will not be dropped.
Yeah,
Okay.
don't do anything.
All right.
Second.
Public comment? Okay, Laura, roll call.
Nancy Springer.
Aye.
Dave Diaz.
yes.
Joan Hancock.
Aye.
Johnny Simpson.
Motion is approved and passed. All right, agenda item E. This is an update on CSLB's legislative proposal for authority to issue a letter of admonishment. The summary language of the proposal begins on page 36. Senator Monning has agreed to author this bill, and it was introduced yesterday as Senate Bill 486. We appreciate his continued support of CSLB, and at this point, committee comments? Public comment? All right.
Yeah. Oh, sure.
We have public comment.
Good morning. My name's Lee Howard. I'm from Ukiah. And I represent the North Coast Builders Exchange. We've been dealing with the board for the last couple of years extensively. And I think for the first time that I've seen in a long time, you have a piece of legislation here that I can't imagine too many contractors not liking. And it protects and moves things a lot faster than it is. The process is so cumbersome, not only for you guys, but for the contractor too, in certain cases. My board has not seen the written on this yet, but I will be taking it back to them. But we had a executive meeting the other day with what we call the MAC committee, and we came up with a couple things that are a concern. One, you are here to protect the public. Is that not what I hear all the time? You're not here to take care of the contractor, but you do to a big degree because we pay the bills for you. The simple fact is that the way that we see this, and we haven't gotten into the detail of it, but 7090, the building code portion of it, and 7110, again, no permits for jobs. It doesn't really spell out in the legislation how it's going to deal with that. Is it just going to be a carte blanche that it's going to be part of the overall scheme of things? Because in your handout you have 7114 and 7118, which are no licenses and dealing with people that are cross licenses. You've put them into a higher category and elevated the penalties for dealing with them. It seems like that somebody should look fairly closely at the 7090 and 7110 to elevate those, because the simple fact is, if this is monetary and all a contractor or non-licensed contractor has to do is go out and do the work and not worry anything except paying the bill for not getting the permits, it's going to make it easier. I think the rest of the stuff, the 29.5, 79.6, the requirements for license numbers and things like this is going to be covered very appropriately with this type of letter. But if the letter goes back to serious things that the public counts on, and I'll just give you one quick example. We had a contractor got called to do some work for a public agency, not a private one, a public agency. The public agency fully expected him to go in and get the permit and do the work. He came and did the work, didn't get the permit, and walked away with the money. What remedied, whether it would be private or public, does the public have to remedy that and bring that contractor back to get the permit and make it protect them? This is a health and safety issue because building permits are there for a reason, just like the license laws are there for a reason. I look forward to working with you guys on this. I'm going to take it to my board and see if we can't get on board to push it and do what we can to make sure it goes. It looks like it's something that can work and cut some of the cost to you, and it cuts cost to the person that may or may not make a simple mistake out there and get this censure letter. I thank you for your time. I'll answer any questions, and I'm available anytime.
I have a question, real quick, sir. Are you asking if or suggesting that it should apply to some sections but not others?
If you're going to give away, and I say that kind of flippant, if you're going to give away the hammer that you have for certain violations in the license law, you should look at those and prioritize those into the severity that they are. There's a big difference if you don't put a license number on a vehicle and you don't, and the other portion is you don't go get a permit for the work you're doing. Does that answer your question?
If I might comment as well, and thank you for your comments, Mr. Howard. I would say that's the intent of the proposal and how staff has presented it, that we use it for more minor violations, such as the advertising violations, and not for more serious ones involving either harm to consumers, a public protection issue. It's not spelled out in the proposal, so we have discussed potentially adding intent language to clarify our intent to make parties comfortable. And then the sections you mentioned that have the higher violation, the 7114, 7118. So that's already an existing law, and the legislature, I think, chose to elevate those. I'm not sure when, but we'll continue our discussions with you. I appreciate your comments, and we look forward to hopefully having support from you.
And I need to clarify too, Lee, that this is just giving us another lesser tool to help the board and the enforcement staff to go out there and write up people that don't have their license numbers. What we don't want to do is tie ourselves down to specific violations to have a specific type of action against them. We want to keep it broad so that the enforcement staff, if they do come across an egregious offense like you mentioned, they're not tied into giving a letter of admonishment. They can go forward and issue a citation or an accusation. So this is going to just give us another tool in our toolkit to go out there and start.
I realize that, Cindy, and like I said, I can see the gentleman that rose to talk about the electricians and those. This is a pretty good place to be able to put that, but I do see some serious things in here, and maybe it just is worked through in the intent when you're doing the legislation, what is really done, because it doesn't spell it out in here, as you say. It's the first cut on this, and so that's why I came all the way over here this morning just to visit with you. So, thank you.
Thank you, sir. Christy?
I just want to clarify, just for the committee's comfort level, that nothing in the proposal gives away any hammer. Nothing in the proposal gives away any ability for the registrar or the board to impose greater discipline for more serious violations. This was simply intended to allow you another method for enforcing the law. Other boards in the department have this very authority, and I can guarantee you they don't use it in a way that would hamper public protection. So we have boards like Pharmacy Board and the Chiropractic Board. They use letters of admonishment, and it's just simply a way to move those more minor violations through. But at the same time, you don't want to put into legislation anything that would hamstring you, as Ms. Christenson said, to a specific penalty for a specific violation. You want to give your staff the flexibility to determine which enforcement tool is most appropriate based on the facts of the case and the type of violation in that case. So that's why it says in the proposal that the registrar may issue a letter of admonishment. It doesn't say shall, it doesn't say what types of violations. May is discretionary. It means that weighing the factors in the case, your prosecutor is going to make that determination what level of enforcement should be applied in any given case. So it's really a very flexible tool, but understand that usually, in my experience in the department, it is used for the more minor violations.
Thank you for that.
So are you assuming that there is going to be a prosecutor involved in a letter of admonishment?
Well, I guess I use that term when under the law is something called separation of function. And when somebody charges somebody with something or levels any type of enforcement action, they're considered the prosecutor under the law. And when it becomes final and it has to be reviewed by a second party, that person's determined to be the decision maker. So when I talk about prosecuting, that's what you're doing when you're enforcing the law. You're prosecuting, you're implementing the law. So that's what I meant by that term.
I recall when we talked about this before, I don't remember, maybe even as much as a year ago, the idea was that it was a in-between action that we wanted to make a point with somebody that was a violator but not necessarily go so far. It would be more than an just as it says, more than an advisory notice, but not so much that it requires meeting out administrative citation. I like the idea that we have stakeholders coming to the meeting to help, educate us with contractors' view of all of this. And I think, I don't know if it requires the necessity of stakeholder meeting over it. It's a possibility. I do, and I'm not sure I'm hearing that what we'd be ogling for is some sort of intent language in whatever we come up with, or that, we are indeed going to look through each and every single BPC code section, I'm not sure how you would handle that, but I'm assuming we handle it that way with intent language when we give out an advisory notice or a administrative citation.
We don't have intent language for those two, but because other stakeholders have raised this issue as well as to what it's going to be used for. We've had discussions at the staff level. Dave and I have spoken about this, and I've spoken to Senator Monning's office as one potential solution to that, if there is a level of discomfort for people, is to add intent language to the bill, legislative intent, that wouldn't specify exactly what code sections we're going to use it for, but potentially that it's for more minor violations. Obviously, we don't have any language worked out, so we would just spend time talking about that at the staff level and with stakeholders, and if we recommend any changes, we'd bring it back to the legislative committee's next meeting.
So given that, I would encourage Mr. Howard, thank you for coming, to follow up and send some information to our board on particular areas you're concerned with. And that's all.
Christy?
One other thing you might want to consider is maybe if the committee or the board at some point wants to do some kind of a letter that would go to the author. That way it could be included in part of the analysis, the bill analysis, as part of the legislative history of the bill, as opposed to putting in actually in the statute. I think I'm a little concerned about putting it in the statute, because then we would get into arguments with people about how you were using the law and implementing it. And I think that, I think, again, you want to have as much flexibility as possible in determining how to implement and enforce your law.
Okay. Any other comments? Any other public comments? All right, so staff will work with stakeholders, and we'll consider that letter, and we'll be talking about this at the next meeting that we have. All right, so agenda item F, which is on page 4344. This is an update on the implementation of Senate Bill 1039 by Hill, and that was a fee increase. You'll see a chart that details the increases. These increases will be taking effect on July 1st. We'd like to thank the IT division for the hard work on this critical issue, so thank you. And then do we have any comments from the committee? Hearing none. Public comment? All right. So we'll move on to agenda item G, page 45, 46. Update on the implementation is Senate Bill 465 by Hill and study and report requirement. I'm going to turn this item over to Bree Brewer, please.
Good morning. Bree Brewer with the Contractor State License Board Executive Office. For those who aren't maybe as familiar with the bill, I just want to reiterate the goal, which is to determine if the Contractor State License Board's ability to protect the public would be enhanced by regulations requiring licensees to report judgments, arbitration awards, or settlement payments for construction defect claims. The steps that we intend to take at the Contractor State License Board to reach this goal is to conduct many stakeholder meetings with main supporters as well as main opponents of the bill, research and compile settlement data we're going to start with 3 to 4 of the larger counties in California and review their online county court documents for settlement information. see if we can acquire that. Also consult with insurance companies about the criteria they use to differentiate between those settlements that are considered to be for nuisance value and those which are not. Also, if need be, consult with our deputy attorney generals and the AG's office to see if there's any other legal resources available to be able to locate this settlement information. Is there a database? Is there some other source we can go to locate this information? Then also review the process from other boards and bureaus that have similar regulations or reporting requirements, that being the Board of Professional Engineers, Land Surveyors, and Geologists. California Architects Board has one as well, and discuss with them how successful they have been with enforcing their regulations. And then lastly, at this point, it would be to examine the cost to the contractor state license board. The support staff that's used, investigators to investigate the cases that will evolve from those settlements being reported to us, or that information, and then any other costs with industry experts, subject matter experts, or the costs from the Attorney General's office to be able to, should an enforcement action be taken, what costs are required there. And then as well as lastly, to evaluate what resources and costs have been expended this far in regards to the Segway case involving the Berkeley balcony collapse, and see what costs have been expended so far for that. And then report on the status in the next board meeting in March. I'll provide a timeline of this and an outline, as well as the statistics on the Segway case that we have thus far.
Thank you, Bree. That was very informative, and we'll look forward to seeing that outline. I was wondering if that's what you were going to be able to do for us. Do committee members have any comments for Bree? Or in general, any comments?
I think you sent out a request asking that myself and someone else work as an advisory. Who was the other person?
Nancy, I believe? Were you the other
Was it-
member?
was
That
it
was going to
you,
be like,
Nancy?
Cindy, you sent an email, I believe, with 2 members?
I'm sorry, I'm gonna plead the fifth, I don't remember.
I believe
it was Nancy and
Joan, yes. So we had 2 board members
Was it
provide
you?
resources.
It might have been you. Okay.
That sounds
So,
familiar? No.
so great. You know, we should stay in contact, maybe set up a meeting, and when you can get over the bridge. Yeah.
And that being said, too, Laura also sent out an email to the interested stakeholders to let them know that I am the point of contact if they have any questions, and that I'll be facilitating those mini meetings when they come about.
Great.
So,
Great, thank you, Bree.
thank you.
Any public comment? All right, thank you for that update. So agenda item H, again, another update on the implementation of Senate Bill 66, but Leva? Sorry, I want to make sure I say that correctly. Information sharing. I'm going to turn this item over to Laura for the update.
Thank you. So we have the text of that bill from last year in the packet, starting on page 52. This is a bill that required the Department of Consumer Affairs to share licensee information with the community colleges to track their success rates. There's going to be subsequent legislation this year. I'm going to ask Richard Markison if he could come up and just summarize what that will entail.
Thank you. The American Society of Civil Engineers was part of a coalition of design professionals and contractors who opposed SB 66 on the grounds that it presented a substantial risk to licensees for identity theft. We sought to amend the bill during its final months in the Assembly, and we were unable to do that. So we have introduced sponsored legislation that was introduced yesterday by Assemblymember Calderon. It's AB 1053 that would, as drafted, would restrict the data sharing to the last 4 numbers of the Social Security number but also require the community colleges to reimburse the department for any costs associated with the data sharing, inasmuch as not all of the databases for licensees are apparently housed in the Department of Consumer Affairs, and since there could be some elements of cost for the Contractors Board to make that data available eventually. Our objective, and Assemblyman Calderon serves on the Privacy and Consumer Protection Committee, which did not hear the bill last year. And actually one of the reasons that he agreed to introduce the bill was concerns by that committee that this was a new state policy or an expansion of existing state policy that would put state licensees at some risk. So our goal is to have the bill hopefully heard at least one policy hearing in the Privacy Committee so that these concerns can be addressed. We're not specifically wedded, at least my client ASCA is not specifically wedded to the last four of the Social Security number. Subsequent research suggests that that's not as foolproof a protection, but we are looking forward to having hopefully a robust discussion about identity theft and the state's obligation to protect their licensees, and we would love to have the board participate in that with either recommendations for changes to the statute, but at some point I know that your board shared some of our same concerns. I would love to have you on board supporting the effort.
Okay, so I just want to caution the members that that item is not on the agenda, so we're here to talk about the implementation of SB 66, so he can talk about it, but you can't.
And
Thank you, Chrissy.
just to add, it will be on the next committee agenda and potentially maybe on the board agenda before that.
Okay, so any committee comments on that update? Not discussing where we're not supposed to? Public comment? All right, thank you all, and thank you, Richard. So that's all we have on the agenda for today. Motion for adjournment?
Adjourn.
Second.
Roll call?
Nancy Springer.
Aye.
Dave Diaz.
Yes.
Joan Hancock.
Aye.
Johnny Simpson.
Aye.
All in favor? We're gone. Thank you. Meeting is adjourned.